Good evening, ladies and gentlemen, and welcome to this webinar, Online Commercial Trials and Hearings, the latest developments from the Rolls building. On the 31st of December 2019, Wuhan Municipal Health Commission in China reported a cluster of cases of pneumonia in Wuhan. A novel coronavirus was identified shortly afterwards, and a month later, on the 30th of January 2020, the World Health Organization declared that novel coronavirus outbreak a public health emergency of international concern. The events of the subsequent days, weeks, and months will shape our lives and the stories we tell for many years to come. COVID-19 impacts on people, businesses, and markets across all sectors, including impacting on access to justice. And courts around the world have had to and continue to take steps to provide viable access to justice and to facilitate resolution of legal problems in the face of COVID-19. In tonight's session, we are privileged to be able to hear from 4 speakers with strong links to England and the London-based Commercial Court on this topic. Before I introduce to them and hand over, may I just go through a few points of housekeeping. Firstly, this webinar will be recorded and a link will be shared on the Bar Council and COMBAR websites afterwards. Thank you to all of you who have put forward questions beforehand. These have been collated and will be addressed both during and after the presentations. Please do ask questions to the panel. I ask that you do it through the Q&A function and not through the chat function. Again, they will be collated and addressed insofar as we can at the end of the session this evening. Could I also ask you to do this now, because the theme is global? Would you please, through the chat function, indicate where you are tonight? In which country are you accessing this webinar? We will be very interested to see that information in the chat. Yes, and already I can see a global spread coming through. Who are we going to hear from tonight? We are honoured and privileged to have 2 judges with us here tonight. Mr. Justice Teare, the judge in charge of the Commercial Court, Mr. Justice Waksman, a judge of the Commercial Court and the Technology and Construction Court. We are also extremely lucky to have with us counsel who practice before both courts, Anneliese Day QC and Matthew Levy. I'm going to now hand over to Mr. Justice Waksman, who is going to give the first presentation this evening.
Thank you very much, Marion. I'm delighted to be here and welcome to you all. The title of my brief contribution is Rules and Procedures. The truth of the matter is that the Commercial Court has been relatively free from new rules or practice directions as a result of COVID-19 compared with other courts in this jurisdiction. That is largely because, first of all, the work that we do is quite self-contained, and secondly, because we normally deal with relatively sophisticated parties and lawyers already familiar with the technology, and we are all very conscious of the fact that we occupy a somewhat privileged position as a result. It meant that when we had to move to fully remote hearings, we were able to do so speedily and fairly seamlessly. There is one set of actual rules that I will refer to in a moment, but perhaps I can begin by looking at some of the guidance. As a result of the fact that we are now opening physically some courts in the Rolls building, we have the following guidance, which has been published by COMBAR, that there are likely to be 4 kinds of hearing now. fully remote with the judge at home, remote hearings but the judge in their room or their court, hybrid hearings with the judge and some participants in court and some participating remotely, and then finally normal physical hearings in which all the participants attend in person. You will appreciate, because of the importance of taking all relevant security and safety measures, and in particular social distancing, and limiting the throughput of people into the court building, we are only running 13 out of the 39 courts that we have in the Rolls building for that purpose. Hybrid hearings have now started. Next Monday, I will be starting an 8-week trial in the Rolls building, which will be hybrid in the sense that I and the relevant lawyers will be in the court, but other members of the legal teams and the principal representatives of the press and members of the public will be joining remotely. I'll say a little bit more about that in the question and answer session. Before dealing with any other guidance, let me deal with the one rule I want to refer to, which is Schedule 25 to the Coronavirus Act of 2020. This provides that if the court directs that proceedings are to be conducted wholly as video proceedings, then it may direct that the proceedings are to be broadcast as the court directs, for the purpose of enabling members of the public to see and hear the proceedings. And the court can also direct that a recording of that is made. Subject to that provision, it is an offence for a person to attempt or to make an unauthorised recording or an unauthorised transmission. Why then live streaming in the case of fully remote hearings? The idea was that if there was a fully remote hearing, then a live stream would provide a solution rather than the alternative, which is for those who wish to see what is going on, taking the initiative and contacting the court staff or the clerk to the judge to see if they can join in the Skype or the Teams or the Zoom conference. Of course, normally in High Court proceedings in the Rolls building, there is no general live streaming provision, as there is, for example, in the Supreme Court. So it is an exception to the normal practice. Without any form of live streaming, then the alternative, which is presently used in many fully remote hearings, is for people to join the conference by being provided with a link to Zoom, etc. Now, of course, a hybrid hearing is not fully remote because the judge is present in court along with other representatives. That creates an interesting jurisdictional problem because the provision for live streaming is confined to proceedings that are wholly remote. However, in my judgment, and I suspect that of many other judges, if the reality is that the only people who can be in the courtroom are the lawyers, and that is tending to be the case because of the constraints on the number of people, the reality is that so far as public access is concerned, it really is fully remote. The trial which I will start next week has provision for 3 or 4 members of the press or the public to come in, but that is it. And therefore, if that's the way that your hybrid hearing is proceeding, then it seems to me the judge is entitled to make a direction for live streaming. As to what live streaming, again, if that question arises later on, I'm happy to discuss it. But while it is an option for the judge, it is certainly not obligatory. Returning to guidance, let me just say something about platforms. I know there's been some questions about that. The default position at the beginning of all of this was the use of Skype for Business and Teams, which obviously are very similar since they're both owned by Microsoft. There has been a question about Zoom. Officially, there is no recommendation for Zoom, and that picks up on the security concerns which have reached public attention. That doesn't mean a judge can't use it. At the end of the day, it's up to the judge to decide what platform is appropriate after making all necessary inquiries. The truth, as I have learned, is that the security concerns about Zoom largely turn on what particular security features are being used. And many domestic users aren't turning any of the relevant switches on at all. As it has been explained to me, once that is done, then the reality is that Zoom is no less secure than any other of the major platforms. And when it is being hosted by a third-party provider, they are able to introduce further security elements as well. Because of the limitations on courtrooms and court space, I rather suspect that for many court hearings, the fully remote hearing is likely to remain the default position, certainly into the end of this legal term. Given that we are talking about technology, it would be inappropriate for me not to end with something with a degree of granularity, as it is called. The other guidance that has been sent to judges and the facility which they have had is improved ability to negotiate, use and edit PDF documents, which of course are the way that most electronic trial bundles are being provided, unless there is a fully comprehensive web-based document platform. The new technology which is being provided to judges mean not only that not only are they able to highlight passages and documents to their heart's content in a highly visible way, they are actually able to take PDF text and edit it. This, of course, provides great opportunities for mischief making. The introduction of a word "not" in a contract could have significant consequences. But assuming that we can be trusted to behave ourselves, that software is certainly going to make the navigation of electronic trial bundles easier. And I think I will finish on that note.
Thank you very much, Judge. And may I now move on to Matthew Levy, who is going to pick up on the technology and the practicalities of using it.
Yes, so a few minutes about technology for remote.
Unmute.
How embarrassing that I'm here talking about technology and I started off on mute. The technology used in remote hearings, when I use that phrase, it gives rise to the assumption I'm going to spend 10 minutes, now 9.5, debating the relative merits of Skype for Business, the HMCTS cloud video platform, Zoom, WebEx, whatever. I'm actually not. We will briefly talk about the choice of platforms, but the reality, as the judge has just said, is that the court has now effectively settled on Skype for Business for all buildings hearings. As advocates, we don't generally get to choose. What I want to focus instead more on is the aspects that are within our control as advocates and as parties, and which I think can make a real difference. One is the setup in our remote environments, another is managing documents, and to which I should now probably add a third, which is knowing where to find the mute button. Having done that, I will talk very briefly, if there's still time, on a conference from tech that might be useful when hybrid hearings become more and more commonplace. So first, let's get it over with, the platforms. The choice of platforms, it's fair to say, is sometimes debated with religious fervor. And often that religious debate comes down to Skype for Business versus Zoom. Well, what do I think? I actually think that Skype for Business is absolutely fine. I also think that Zoom is absolutely fine. And in light of what Mr. Justice Waksman has just said, I feel liberated to say it's actually my favorite choice. But there are several options. And the truth of the matter is they all have their pros and cons. And spurred on by a massive increase in use, thanks to coronavirus, the platforms are all getting better all the time. So you look at the sort of function set of, say, Zoom today, or Skype for Business yesterday, and it's not necessarily, you're not comparing apples and apples if you look at this week's version of something versus last week's version of something else. So, I mean, in a way, it doesn't really matter. I haven't done a controlled experiment to establish which platform delivers best sound quality, best picture quality, which has the greatest array of features. I haven't also done an experiment to work out how to sort of maximize the benefit of each. But what I can say with absolute confidence is that the platform choice, whether it's Skype for Business, whether it's Zoom, whatever, is not even close to the most important factor in determining the sound quality and the visual quality. And ultimately, although we have various platforms with various features, the things which really matter at the end of the day are, can we all hear each other? And to a lesser extent, but still quite important, can we all see each other reasonably well? Now, if you're asking those two questions, actually, the real things that make the big difference are not the platform, as I say, they're the microphone, the speakers, the camera, and the room. Now, it's starting with microphone. Built-in laptop mics, that's what a lot of people use. I mean, they're not universally awful, but they quite often are. People tend to sound very distant or distorted, or if you're really lucky, both distant and distorted. They also generally don't have that great sort of software behind them, so they tend to pick up a lot of background noise. They're not necessarily selective. So until recently, the accepted wisdom was that this was the only other option available. And Anneliese is sporting one this evening. They work very well, but they are no longer the only option for good sound quality. There are alternatives. Now, you can, it's fair to say, go utterly berserk over this. And I know of certainly some members of the bar and many other people in other professions who have the most astonishing looking microphones on their desk, which cost a lot of money, and they are very, very good. Fine if you want to do that. But my view is it's completely unnecessary. Some more reasonably priced, by which I mean sort of 2-digit sum in sterling options, you can have pretty good quality with a lapel mic. You know, the sort of things that news presenters use. Little things they're attached to your lapel, they have a long wire, and in the modern incarnation, you then plug them into the USB port of your computer. What's really good about those is they pick up the voice clearly, they minimize noises from the ambient noises from around the room, and they're generally pretty cheap. What I'm using now is a monitor top webcam, a Papalook, with a built-in microphone. It's unlike a lapel mic, I don't need to wire it up before starting, which is a help. It's always there. It's currently about 50 centimeters from my mouth, but it's got active noise cancelling. And so it's a massive improvement on a laptop mic, although probably not quite as good as a good quality lapel mic, or indeed a good quality headset. So that's microphones, invest in a decent one. The next factor in an advocate's control, to an extent it's in an advocate's control, is the environment. This may sound obvious, but actually it's incredible what difference you can make to an ambient noise footprint by closing the window, shutting the door, switching off the washing machine, since we're often working at home. I used to run a sound recording course for music undergraduates a few years ago. And one thing that always struck me is how little people think about controlling acoustics. So once you've switched off the washing machine and closed the door, try not to set yourself up for a hearing in an austere square room with bare walls and a wooden floor. Soften it up. I mean, even if that's just strewing the place with some duvets and quilts, that makes an astonishing difference, actually, to an otherwise echoey room. Then, I mean, that's really sound for you. Then the camera. My view is, and it may be that the judges disagree with this, but my instinctive view is that the camera does matter less than the microphone, because to be seen and to see is a useful luxury, whereas to hear and be heard is essential for the hearing to work at all. And I think generally a bog standard webcam works just fine. If you want to buy a Swish 4K resolution camera, by all means, but two things. Firstly, invest in the microphone first, and secondly, think about network quality. because the quality of the network is the other thing which makes an absolutely enormous difference. And if you're throwing high resolution video over it unnecessarily, you're squeezing the available bandwidth available for your voice, and you're causing yourself potentially latency problems, which is where your voice starts to go like that. Now, if you're working from home and you're using public internet and broadband, there's a limit to how much control you have over networking. From time to time, there are going to be problems, there are going to be glitches. But what you certainly can do is minimize the self-inflicted jitter. I've just said that unless you're blessed with high capacity broadband, do switch off high-res or video. Then unless you're a networking guru and you've spent a lot of time playing with quality of service on your home network, then it's time to rescind Netflix rights for the children for the duration of the hearing, and YouTube, and anything else which involves a large bandwidth streaming, basically. The other thing people often forget, we're so used to everything being wireless these days, is actually plugging in the good old-fashioned way with an Ethernet cable is generally better because you don't risk interference with neighbors, other people in the house, and so on and so forth. Even the humble home router which comes through with your broadband will have a few Ethernet sockets at the back. Plug one of them in, it does generally work better. Now, one more tech point on tools that you need. At least as an advocate, what you really want, if you can possibly do it, is lots and lots of screen real estate. You want the Skype session or whatever it is to be a reasonable size. You want to be able to read the bundle. You want your working notes, if they're not on paper, and you possibly have a transcript as well. Now, some people have multiple screens, and if you're doing that, 4 seems to me to be probably the respectable minimum. I really hate doing that because I always end up looking in the wrong place, and it's really confusing trying to drag a window between screens. You never know which screen it's gone to. I prefer one screen. I have one screen, but an extremely large one. The screen I'm looking at now is a 50-inch screen. I have 6 windows open on it. There's room for everything, and even with my slowly failing eyesight, actually I can read absolutely everything. So that's all I want to say about platforms and ways of accessing them. Bundles. Now, if you're using a Magnum type service, the bundling has been outsourced. It's taken out of your hands and it just works. Good. But otherwise, it's something that needs to be well handled. The technology of choice, and I'm delighted to see this is the technology endorsed by the COMBAR guidance, and I believe the court, is the humble PDF. It's a wonderful format and massively underappreciated and has been for years. It's universally readable. Literally anyone, whatever their computer, can download and read a PDF file. It's really powerful. It can be indexed and searched. You can have embedded bookmarks to mark different sections. You can have internal hyperlinks to jump between pages. And if you really want to, I wonder how many people on the call knew this, you can write fully working Turing powerful program, Turing complete programs in the PDF programming language. It is a programming language in its own right. It's amazing what you can do with it. It's also very easy to share PDF files. You send them by email or whatever. Now, the COMBAR remote hearings guidance document, can I draw everyone's attention to paragraph 11, which tells you how you should be producing a PDF file for an interlocutory hearing. I won't read out the whole paragraph, but it's worth just flagging a few points. It suggests a single PDF file. And how do you make a single PDF file usable? You have an index at the front with clickable links, and then suddenly it's not a PDF file, it's a really useful tool. Another point they make in that very useful guidance is make the text editable or highlightable. In practical terms, what that actually means is run it through a preprocessor. A good quality PDF editing package will pre-process it. It'll do, even if it's scanned, it'll do some OCR for you, and it'll get the PDF file in a state where it can be highlighted and actually generally searched. Keep the resolution low. Sorry, I'm just getting a secret message here. Yes, thank you. I've been asked to circulate the link to the COMBAR guidance, and we'll do that afterwards. Keep the resolution at 200 to 300 dpi. The thing about that is it's a little bit like camera quality. you don't have to have the highest quality for your PDF files or indeed any other sort of files in order to make them legible. As you increase the quality, yes, the graphics look more beautiful, but you're massively increasing the size of the file. That makes it A, difficult to share, B, slow to load, and C, slow to scroll. So a small file, lower resolution, generally works better. And also one more point on this, hyperlink from your skeleton to the bundle. You suddenly have an electronic tool which allows you to do useful things like hyperlink between documents. So as advocates, we should really be using that. Now, the guidance for trials, I'm not going to tell you much about, except to say that it's broadly the same, except you use multiple PDF files, one per bundle, and you use bookmarks within the PDF to separate out the tabs. Now, doing all of this and doing it well is surprisingly easy. All it requires is investment in a decent PDF editing tool. There are loads of them out there, and for those who haven't dabbled previously, look again at the COMBAR guidance, which has a few suggestions. Now, Marion, do I have 1 minute left? 1 minute left. So the last thing I want to touch on is hybrid hearings. So when the restrictions start to lift and we have more and more hybrid hearings, I can envisage the possibility that you may have a legal team in a conference room in chambers, for example, connecting to a hearing that way. And I just wanted to flag, for those who didn't know, that these days there's some quite good toys you can buy to help with this. You can have sound bars and screens which allow a room full of people to sit in front of one microphone, looking at one screen, and the microphone will pick up who's talking and filter out the other noise. And you can have cameras which zoom nicely to the face of whoever's speaking. This could be a whole hour talk in itself, but for now, all I wanted to flag is that if you're starting to do conference rooms in solicitors' offices or conference rooms for hearings, please look at the tools that are available.
Very much, Matthew. Can I just say that we will in fact be circulating the COMBAR guidance that Matthew referred to everyone who is registered for this webinar. And Anneliese, over to you, talking, I believe, about advocacy and communicating in real time.
Thank you very much, Marion, and good evening to all of you. In one way, everything seems to have changed, but in another, my message to you is that nothing has changed. Some things remain exactly the same, and the importance of preparation, which is often said to be 90% of good advocacy, preparation remains absolutely key, and even more key when you are conducting advocacy in real time. Obviously, the importance of written advocacy may be further increased. We are very fortunate in our jurisdiction to have judges who read in advance, and therefore a judge may have formed views before he or she even walks into the virtual hearing. But I think that our long tradition of oral advocacy is still very much alive and kicking. And it is important to remember that we are still in the business of the art of persuasion. So do not believe that you just submit the written documents and then you turn up like a robot and make submissions and it makes no difference. I have both conducted hearings as the advocate, but also as an arbitrator. And it is amazing that you can still have your mind persuaded by what somebody says, having thought one way before you walk in, having read the written submissions. Now, I want to make some points which I'm sure will be obvious, but might catch some people unawares. Obviously, in a virtual hearing, you cannot hand things up during the hearing. So you have to think in advance, is everything I need in the bundle and available to the judge? Judges will not thank you for a flurry of late documents. To date, the judges I've been in front of have been incredibly patient with dealing with late documents, but I suspect that that patience will wear more thin. Find out in advance how the judge who's hearing your hearing or trying your trial wants to work. So some judges are now starting to move to being purely electronic, and some still want hard copy bundles. So some have both. And again, there's the same similarity between the old and the new world. Good bundles are so important, Matthew's obviously talked a little bit about how we can use the electronic system to make things even easier. And Mr. Justice Waksman also talked about the ability of judges to highlight. But there may still be judges who prefer to work off hard copy bundles. And to date, I've seen it work very successfully, and solicitors have gone to great efforts to ensure that people have whatever suits them to work from. Find out whether your judge likes to have all counsel who are speaking on display on the video. Judges have different preferences on that. Obviously, make sure that everyone else is muted and off their videos. In terms of do's and don'ts, my headline point is don't be afraid. I have been amazed by how the judges and arbitrators in this jurisdiction have been utterly amazing in terms of embracing the situation we are in and making it work both fairly and effectively for all concerned. It's been incredibly uplifting to see it working in that way. Do make sure that you have a test run before the hearing. Often in court now, the clerk will do that the day before on behalf of the judge. It's incredibly useful just to make sure everyone can be connected up and be heard and know the general ground rules. And obviously, Matthew's talked a little bit about camera, lighting. People have asked about background. I think just have something that's reasonably neutral. I know some people like peering into other people's houses, so I don't think there's any set rule about having it completely neutral. Make sure, obviously, you know how to work the tech. Having the tech's great, but it's another thing working it. And as Matthew has said, be able to run transcripts in particular at the same time, particularly if you lose the link or you can't hear. Transcripts are incredibly important. When you're doing advocacy on a video, brevity and succinctness are even more important than in the real world. There is no room for waffle. Now, the judges may be very glad about that, but it really, you can tell the difference between advocates who've thought very carefully about what they are coming into the hearing to say, so not simply regurgitating what is written down, but advocates with a clear structure, signposting where they are going. Do not interrupt your opponent. Take any objections at the end. If you interrupt, it completely stops the flow. To date, because everyone's been getting used to the technology, I've found that judges often let you speak for longer than perhaps might be the case in a normal courtroom, so to speak. I think that may change going forward as people become more confident with the technology, but you may have to speak for quite a long time. I found it slightly discombobulating to start with, that the judge sat there and politely listened for longer than perhaps I might have expected. Make sure that everyone is trained. So if you've got witnesses and experts, make sure that someone has gone through with them, you know, how they're going to look. I had an expert who put a camera very low down and we just looked up his nose and it was rather off-putting. So make sure that the witnesses, particularly lay witnesses, are they comfortable? Have they got their tech set up? Do they know where the documents are? I had a lay witness who was extremely flustered because he was working off his wife's iPad. I'm not really sure he could give his evidence very effectively because he was just so stressed that he wasn't familiar with the tech. Make sure you've muted yourself when you're not speaking. Obviously tonight we've seen some things of people being muted when they should be speaking, but we've all seen the public examples of people not speaking when others can hear them and perhaps not wanting to be heard. Obviously, quiet space, Matthew's talked about that. Make sure that all children and animals are out of the way, but equally if they appear, try not to worry. I've certainly had at least one of my children crawl in when I was cross-examining an expert witness and trying to pull my hands and send me messages. In fact, I don't think anyone noticed, but don't let it put you off. Obviously, try and ensure that any potential distractions can be removed. Screen sharing can be very helpful. On Zoom, it's one of the functionalities at the minute that if you've got a document, for example, where a contract and you're construing certain provisions, it can be incredibly helpful to be able to display that to everybody on the screen at the same time. Communicating with the legal team and clients. I know clients were very worried that they can just not have access to the barrister. I've actually found the opposite's true. So normally in court, you have the note being passed up along the line dutifully to solicitor, to junior counsel, to leading counsel, and leading counsel often ignores half the notes. Now we're subjected to WhatsApp bleeping, and often with clients on the line as well. Again, make sure you've thought about how you're going to communicate with clients and solicitors before court, for example. Do you want to do it the night before? But remember that clients still want to be reassured and to know that you have taken on board all the points. Some brief points on cross-examination. Short questions. Don't interrupt the witness or talk over each other. The transcribers won't be able to deal with that. Remember that you will lose some immediacy. So planning is absolutely essential. Make sure that the documents are in an easy format to show the witness. If you're cross-examining an expert, remember if you're using spreadsheets, etc., that those will need to be able to be displayed or found by the witness. Obviously, be patient if there are technical difficulties with a witness. Try not to take that out on them. Aggression, in my view, comes across even worse on a screen. I think we've been losing that from our tradition recently, but calm, clear questions are so much more effective. And do remember that you can actually see facial expressions even more vividly on a screen. So particularly the witnesses, I've been amazed by what you can actually see. You can sometimes see more than you would in a real courtroom. And likewise, you know, train your witnesses so they know that. And if you're on a screen but not speaking, remember people can still see you picking your nose, looking away, doing other things. So you are still on display even if you're not physically in the same room. The only other thing that I wanted to raise, I'm at the end of my 10 minutes, is just the issue of concurrent evidence with experts. And this is something that's been discussed in the arbitration arena, and it's something that I'll be interested to see if the courts explore. But obviously one of the bugbears in cases involving expert evidence is that the experts go off on two different tangents. They produce joint statements that don't agree anything. And certainly within the arbitration sphere, I've seen tribunals now ordering experts to have a video hearing as part of the case management, and actually questioning experts as to what they're going to answer and directing them at an early stage. So again, technology brings additional flexibility and benefits. And my final message to you is therefore embrace it, let's get the best out of it, and let's ensure that we continue to maintain our wonderful tradition of advocacy in this country.
Thank you very much, Anneliese. Before I move to Mr. Justice Teare, could I just point out that there are one or two questions in the chat box. Could you move them over to the Q&A function? And if anyone's got a question, please do feed them into us. And now it's Mr. Justice Teare with insights.
Good evening, everyone, and thank you, Marion. I've been asked to comment on remote hearings from the judge's perspective. It is remarkable that the commercial court has continued to hear almost all interlocutory applications. The Friday list looks as busy as on any Friday before lockdown. Trials involving live witnesses have on just a few occasions proved impracticable. For example, where a witness was in a remote location in Spain, locked down and without reliable internet access. But there have been very few adjournments for that sort of reason. I doubt that there are many observers who would have predicted before lockdown that so much legal work could be conducted remotely. There is certainly no unmanageable backlog of work. From the judge's perspective, the preparation for a remote hearing includes not only reading that which he or she has been asked to read, but also ensuring that the essential materials are open on the screen and ready for immediate access. Immediate is perhaps a relative term. I am sure some judges who use 2 or even 3 screens have very rapid access to the electronic materials as and when they are referred to by counsel. Others, such as myself, use only 1 screen, and I am sure I sometimes take a little longer to bring a document up than others. Hence, placing the documents along the bottom of the screen, ready for access, is very important. It follows, as has been said by others, that the preparation of electronic files by the parties is very important. The electronic bundles not only need to be labelled electronically, but must also be easily navigable once they are open. The ability to find particular pages in PDF files is very helpful, but hyperlinks are even better. For many judges, though not perhaps all, the nature of remote hearings is such that documents should only be referred to when it is truly necessary to do so. That in turn suggests that it is not necessary to prepare electronic files with all the documents in a case, only with those which truly are necessary for the hearing. That is a good discipline and will be of benefit when we return to more conventional hearings. The judge's clerk also has an important role in setting up the remote hearing and ensuring that those who require access get it. Where required, the clerk also arranges a test session the day before. The clerks have been excellent in doing this, and it is very gratifying at the end of a hearing when counsel go out of their way to thank the judge's clerk for the assistance he or she has given. Particular care is required when it is necessary to sit in private to discuss certain matters and then to return into public session. This again requires the services of the judge's clerk, who is able to set up a private hearing restricted to the parties, and then, when appropriate, to arrange for journalists to join the public session. Where sitting in private is contemplated, the practicalities should be discussed between the parties and then with the judge as early as is possible, so as to ensure that the remote hearing is not too disjointed or interrupted too often. The preparation for a remote hearing requires a high degree of cooperation between the parties. In my experience, even in those cases which are, as it is said, hard fought, such cooperation has been manifest. Without it, and without a desire to make the remote hearing work on both sides, few remote hearings would take place. The hearing itself is, I feel, more intense than a conventional hearing. It is difficult to say why this is so. One certainly feels much more tired at the end of a remote hearing than one does at the end of a conventional hearing. For that reason, breaks are required, and not just for the transcribers. As Anneliese has said, it is always good advocacy to be concise and clear. But when the hearing is conducted remotely, those qualities are even more important. Again, it is difficult to say why that is so. Perhaps it is because there is a feeling that the facility of a remote hearing is fragile, and that it is therefore essential to ensure that your points are communicated to the judge when the link is sound. Perhaps it is because the level of concentration required in a remote hearing is such that woolly or verbose submissions can be more readily detected. I do not know, but certainly concise and clear submissions are a boon in a remote hearing. Speaking for myself, I find that note-taking of points made and of page references is even more essential than in a conventional hearing, when one has several key documents open before one and one can write notes on them. For that reason, concise and clear submissions are necessary. A remote hearing also imposes a discipline on the judge. One tries not to interrupt in a conventional hearing, but I think it is even more important not to interrupt in a remote hearing. When one does so remotely, it is often the case that the words of counsel and judge are lost, neither knows what the other has said, and each has to start again. Obviously, there will still be questions which a judge must ask, but in a remote hearing, the judge's questions are likely to be less frequent than in a conventional hearing. Another matter, again, which Anneliese has touched on, is that a judge has to bear in mind that when he or she asks a question which requires counsel to seek instructions, counsel obviously needs time to do so. He or she has no junior or instructing solicitor sitting behind him or her. And if some court hearings take place in the near future with social distancing in court, that will remain an issue. We are all used to witnesses giving evidence by video link, and so witnesses giving evidence in a remote hearing is not new, even where fraud is alleged. What is perhaps new is that instead of having hard copy files, the witnesses also use the electronic documents. So it is important that they have the necessary ability to navigate the documents. In my experience, it is usually essential that they have at least two screens, one showing the advocate questioning them, and the other showing the document about which questions are being asked. Are there downsides to remote hearings? The judge has little feel for the atmosphere in court because all he sees is the face of counsel addressing him. The only indication that others are observing is that at the outset of the remote hearing, the software states how many people are attending the session. In my last remote case, there were over 60. Yet I had no feel for that. Is that a downside? It probably is, but on the other hand, it is difficult to identify any unfairness which it generates. May I finish by saying that I have been hugely impressed by the ability of the bar to adapt to remote hearings. The efficient and fair conduct of litigation in this country is achieved by a marked degree of cooperation between bench and bar, founded in mutual trust and confidence. That has been demonstrated by the recent experience of remote hearings. The judiciary is, however, well aware that not everyone may have the ability to participate in a hearing from home, having regard to the other domestic upheavals caused by lockdown. So far, that problem has not surfaced in hearings before me. But if it is a problem, as it may undoubtedly be in some cases, the bar should not hesitate to bring such problems to the attention of the judge who is proposing to conduct a remote hearing. Thank you, Marion.
Thank you very much. And we've had a number of questions in. There seems to be a couple of general trends emerging. And could I ask Mr. Justice Waksman just to explain a little bit more how a hybrid hearing works? There seems to be a particular interest in where the camera is placed.
Thank you, Marion. Yes, precisely how it will be arranged depends on what facilities the parties are able to offer the court, because it will all be down to their equipment rather than the court's equipment, although the court recording system can be fed into the platforms which they use. If there's going to be any kind of live streaming, it can actually be done with a Zoom platform as its foundation. And what has happened in the case that I am dealing with is that there are 6 or 7 different cameras. They're quite small and unobtrusive, and they are placed around the courtroom. And the operator is then able to show the person who is speaking at the time. And so in that way, the observer of the live stream is able to see the essence of the process. From what I have seen so far, it's not generally the case that you will have a camera which will show the entire courtroom. They tend to be more focused on the speaker, and in that sense it's a bit more like a Zoom experience. In the case that I'm doing, there is a corner of the courtroom which resembles something out of Star Wars, and I stay well away from it. Either that or a DJ's kit with operators who are able to do all sorts of things in terms of what they pick up and where they send the signal to. That's the technology side of it. Otherwise, the courtroom is fitted out in the way that any courtroom would be, except that there are far less people. The tables in the Rolls building are so wide that it's never been possible for a solicitor to do what they would do in the old days, which is to lean across and tug the gown of the barrister, who in fact isn't wearing a gown anyway. What they can't do in these situations is what they would otherwise do, which is simply walk around with a note, because that immediately causes problems with distancing. And so what they tend to do, whether they're in court and sitting behind someone or out of court, is then send messages using any particular system that they want to use. But otherwise, I think someone also raised the question of robes. Well, we don't wear robes generally in the commercial court anyway. Headphones was raised. That was about remote hearings. I don't have a problem with it. I'd be interested to see what Mr. Justice Teare says about that. There was a question about informality. I try to reproduce the courtroom as much as I can when I'm conducting a remote hearing. I want to bring in a coat of arms as my background, but I haven't quite managed to do that yet.
Because informality is coming up as a big issue, and I wondered if Mr. Justice Teare had a view on how you handle, assuming that one wants to maintain formality, just assuming that, how does one do that in this context where we are all sitting in our rooms of our house?
I'm not sure there's any special solution to that. I think, as Mr. Justice Waksman has just said, one tries to conduct the hearing in the same way as one would a conventional hearing. Again, it very much depends on the trust and confidence between the bench and the bar. The bench is, generally speaking, happy to let counsel say what they wish, and counsel is happy to answer questions which the judge has to put. I think at present I simply try to follow the procedure and practice of a conventional hearing.
Thank you very much. And Anneliese, there's a whole stream of questions, and this is just for counsel. What practical steps are available to ensure that witnesses giving evidence remotely may not be receiving assistance off camera?
Well, I think physical assistance you can see as easily, if not more easily, than if you're in a courtroom. So I don't think that's an issue. I certainly had an issue, though, where a witness's email kept bleeping, and my clients became very concerned that he was receiving messages. So, I mean, there isn't, but I think it will be obvious. Maybe I'm too optimistic, but I think if someone is being fed answers to questions, that it's going to be obvious that they're reading off something. So yeah, I'm not sure you can do anything short of, there's been discussion of physically having someone. When witnesses used to give evidence by video link, there was normally someone who sat with them. So if there's a particular concern and there's a particular reason, then I think that could be a way forward now that we can actually travel and be somewhere where people could still be socially distant. So if there's a particular concern, think about that in advance. Certainly with professional witnesses, experts, they should be able to be trusted. But I do understand the concern, and I think it has to be dealt with sensibly, depending on the circumstances of each case. Does anyone want to add anything on that?
and I'm going to assume you're all happy with seeing your opponent or counsel with headphones on. Any comments on that one?
Well, Matthew already told me off for looking like a moron for wearing them, but yes, it helps. It also helps, you know, you get into the mode of it. You're sort of in the mode then of, so I think it's all personal preference, isn't it? We're all doing our advocacy sitting down rather than standing up. We can't walk around the room. So I think, you know, see what makes you feel most comfortable.
There's a number of questions coming up as to how do you deal with ensuring access to the public. That has been dealt with in the rules and procedures. Do you have any tips for council as to what they should be doing in relation to that?
Sorry, do you mean in terms of council taking the initiative as far as public access is concerned, or were you thinking of something else?
The questions seem to be covering both. Who's responsible and what steps, if necessary, should be taken.
Well, if I can just say something on that, as I've indicated before, the judge has a degree of leeway about it. Somebody asked, why don't we have live streaming anyway for all hearings? The answer is we don't. The technology isn't there to do it for all hearings, and decisions have been taken way above my pay grade as to what sort of hearings should have live streaming. Given that we don't generally have live streaming, it has to be remembered that public access is generally generated by people who come into the courtroom and sit down and listen to proceedings. If you have a small courtroom, you always have a limit on the number of people that can come in. That's just the way that it is. I don't think it's particularly the responsibility of the lawyers to arrange for public access. The judge has got to take a decision about it as to whether they do anything more than access to Zoom in a fully private hearing. The rules or the guidance say that if you have a remote hearing, then provided there is a facility whereby a member of the public or member of the press can contact someone to get a Zoom link or a Skype link to the hearing, that is then considered a public hearing.
Are there any other comments that anyone else on the panel would like to add to that?
No, just to say on the last question though, someone's helpfully pointed out that you can also have cameras in the room on the witness to check that they're not doing anything. But I would be surprised if that was to happen in every single hearing. But certainly, again, that's another option to having a live person. Someone's helpfully put in the Q&A some camera names that can be used.
And there seems to be a lot of questions being asked about the forms of PDF software. It's probably not for us to advertise any particular branches. Perhaps you can take that offline with Matthew, unless anyone wants to particularly promote a PDF answer. No, Matthew is just smiling. I don't think he does.
I think that's probably not somewhere I should go.
Okay, then the questions that are coming in, someone wants to know about using a virtual background, say a bookcase or a library. Would you recommend? Can I just say that I've seen that when people use one of those virtual backgrounds, the flickering that happens when they move is really completely disconcerting. Are you aware, Anneliese, Matthew, that you are involved in hearings in which your opponents are using these backgrounds? Perhaps you're using them now, I don't know.
On that, there's a difference between using a Zoom virtual background, where you do get weird halo effects around faces and things, and having a proper green screen, whereby you literally have a piece of stretched, taut green fabric behind you. Generally, if you have a proper green screen, the artifacts are not nearly as bad. But if you use the really rather clever sort of Zoom software that doesn't require you to have a green screen, then you get artifacts. It's doing something quite complicated if you think about it. It's trying to work out which bits of the image are you and which bits are the background.
Does anyone want to add anything on that one?
I've never seen them virtual backgrounds used on hearings, and I suspect the judiciary might have something to say if you turn up looking like you're on the beach in Barbados, but I don't know. I also think Mr. Justice Waksman needs a blind, which is an example of, you know, if he was making his submissions.
Well, that's absolutely true, and it's my fault for not getting the blind and deciding to sit in the window where the sun is streaming through. I entirely agree with you about those sorts of backgrounds, which do cause some very strange effects. I think the bottom line is that you just need to have something behind you that is fairly anodyne, and whether you're a counsel or a judge, you just need to make sure that there is nothing there that shouldn't be there, or that could distract, or anything of that kind. But beyond that, I don't think it's necessary to go.
Now, there's an intriguing question that's been asked, which wants to deal with the question of interrupting a witness. Situations, it's posited, often arise where the witness expert is going beyond the scope of the question asked on cross, and persistently so. And one tends to want to interrupt so as to bring the witness or expert back to the question, if nothing else. Have you considered establishing a non-verbal protocol for interruptions? A non-verbal protocol for interruptions. Starting with counsel, has anyone established one to date?
I've been very lucky, actually. The judge or the arbitrator has intervened when that's happened, naturally, just to tell the witness politely to, you know, not to answer questions. I know Lord Newburger used to say that he broke a pencil if counsel was boring him, just to, you know, move on with things. But I do think that interrupting or badgering or trying to say that to people, if you're counsel, is quite difficult on a remote hearing. I guess then you would perhaps raise it with the judge if you felt, but I think you have to trust in your tribunal to control the witness a little bit more, and think about it when you ask the questions, because sometimes it might be the question that, ask a question that is clear and demands of an answer, rather than something that allows the witness to meander.
I've had one hearing where we introduced, I think at the suggestion of counsel, a sort of non-verbal protocol, which was simply to put up your hand if you wish to say something while someone else was speaking. And it worked very well.
I think that I would agree with what Mr. Justice Teare has just said. Put up a hand or put up a pen is sufficient, and you tell them in advance that if you do that, it means whoever is talking should stop momentarily because the judge needs to say something. I think equally that what Anneliese has just said is very important. I think that the judge needs to be very alive to the possibility that the witness may be going way beyond their brief, or their instructions, if they're an expert, or their expertise, or another witness is giving some evidence which they shouldn't. Because under normal circumstances, although the judge, of course, must be aware of what is going on, there is someone else in the room. There is counsel in the room, either that witness's counsel or the other side's counsel, who can immediately do something. It is more difficult in these remote hearings. And I think, therefore, that the judge who is in charge has got to be very alive to that. And I think that if it's a question of the expert witness departing from their expertise, then it's likely to be the judge who will stop the witness and get them back on track.
The new questions coming in, the thorny topic of time estimates, which of course every counsel is immaculate at providing under the existing system. The anodyne question is asked, how have time estimates been affected by this move onto the remote platforms? Are we giving shorter, longer ones? Are we giving more accurate if we weren't managing to do that before? Any views? Who'd like to comment first? Mr. Justice Waksman, was that indicating you'd like to comment, or?
Well, been commenting quite a lot, but if no one else wants to start, I would simply say this. You have to allow more time. The procedure itself means that there can be gaps between who is speaking, and you've got to allow their microphone to take over, as it were. There may be some problems at the beginning, even if you've had an expert, as to when you get going. And of course, very importantly, you do need to have that mid-morning break and that mid-afternoon break. But I think these days, the judges will expect the advocates to take that into account when they say how long the hearing is going to be.
And yet when it comes to the interlocutories and case management conferences, the advantages of short, sharp submissions being pointed out, are you finding, counsel, that you're actually being able to estimate shorter times when you're not dealing with witnesses and the day-long hearings?
Yeah, I mean, my experience actually of just submissions is often they run shorter. And I think that's partly due to what Mr. Justice Teare has identified, which is screen fatigue, that people actually can't concentrate for as long. So we've had some, closing submissions that actually were shorter. And it's something to bear in mind when you're writing your oral submissions, that you may not be able to go for as long and hold the attention of everybody for as long. So perhaps slightly shorter days, but 3 days rather than 2, if possible. It depends on the case.
Yes, I have found that with remote hearings, the structure of the hearing is more often than perhaps with conventional hearings agreed, and counsel are particularly scrupulous in keeping to those estimates or the timetable for the hearing. Quite why that should be so, perhaps it is that the structure of the remote hearing seems to require people to abide by the rules even more clearly than they would otherwise do, but certainly that's been my experience. I certainly haven't had people overrunning.
Picking up on screen fatigue, any tips about dealing with the translators that are quite often used in the commercial court? Translators, and also it's being asked about transcribers. Presumably regular breaks were built in anyway, and the problem of dealing with a translator when you are witnessing is that slows the process down of itself, and perhaps you have to build in extra time just to deal with the technology that's going to exist between the two. Or do you put the translator appropriately distanced into the same location as the witness? Any thoughts, any comments, any experiences to share on that?
I mean, I have some on transcribers. I found that they're remarkably good. It doesn't really make any difference to them as long as they can hear. So the problem with transcribers is if the link drops off, or they can't hit, someone's talking too quickly, or the worst thing is over speaking. But as long as those things are present, I don't think transcribers need any more breaks. I haven't had any experience yet of translators, but I can certainly see the advantage of having them in the courtroom, if at all possible, if it's a semi-remote hearing. And I can see that that's likely to cause particular issues.
Anyone else? Well, I think as a last question, someone has just said, is telephone better for an interim hearing? The good old telephone conference. Or are we now here to stay in the days of the video conference? Any views on that, or any one last message you would like to leave? If you had to sum up the message that you have in relation to online hearings and the view from the Rolls building, one last tip from each of you. And shall I take you in the same order that you spoke, Mr. Justice Waksman?
Yes, I'll just mention two things very quickly. First of all, I was very interested to hear what Anneliese said about concurrent evidence, sometimes called hot tubbing, which I piloted in Manchester, and I'm personally a great enthusiast for. Actually, regardless of preparatory hearings, this is one area where the courtroom environment is almost essential. because it's the area where you actually have the expert witnesses usually sitting pretty much side by side, and it's the dynamic between them, chaired by the judge, which enables them to have what becomes much more a constructive dialogue than them feeling that they are fending off brickbats hurled at them, I'm afraid to say, by aggressive counsel. That's their perception. It's not what happens. And that is actually somewhere where you've really got to have a courtroom hearing. For my part, I think that there are many advantages to a simple Skype hearing over a telephone hearing, because there's really no reason why you shouldn't have it. There's lots of reasons why you should, not least the fact that it used to be the case that you have BT conferencing that somebody had to pay for and all the rest of it. And now all of that has gone, and at least you can see the people that you are dealing with. I think my takeaway from all of this is that I've been hugely impressed to hear from the advocates how much they have embraced everything going forwards. I'm sure there'll be continuing debates afterwards about the role that remote hearings will play. But I feel personally very privileged to be a judge where the lawyers who deal with me have frankly made my life so easy.
Matthew, very quick to unmute.
Yes, firstly on telephone hearings, I couldn't agree more. Why would you ever want a telephone hearing now? If I had a prediction, it would be that as we come back to normality with the court process more generally, and we come back to in-person hearings, this aspect will stay, where otherwise you might have made to do with a telephone hearing. The one tip I would have, and you've preempted me, Marion, is don't forget the mute button.
Okay. Thank you. Anneliese.
I found myself having to do an appeal in Dubai in the DIFC by telephone. It was unbelievable. It was all because they're paranoid about Zoom or any technology being hacked by anybody. And it was incredibly difficult. And I would reinforce what everyone else has said. It is much, much better to be able to see the face of somebody. And I do think that in terms of interlocutory hearings, there may be a place going forward for some of those to be dealt with remotely, particularly where you've got people in different jurisdictions. And my top tip is, don't be afraid to wear the headphones.
And I nearly forgot to unmute. Mr. Justice Teare.
My tip concerns electronic documents. Counsel should not assume that the judge is as up to speed as counsel is with navigating the bundle. If the judge appears slow, or indeed even having difficulty in finding the relevant document, counsel should not hesitate to give him some advice. Speaking for myself, I've received several very good tips during a hearing as to how to navigate the bundle, and I would therefore recommend you all to do that.
Well, can I, aware of screen fatigue and of the demands that we have put on our panelists at the end of a difficult day, can I first start by thanking those of you who've attended from Abu Dhabi, India, Pakistan, Hong Kong, Japan, Switzerland, the USA, Georgia, as well as England, Wales, Scotland, and Northern Ireland. Thank you very much, and thank you for your questions. I'm sure you will join me in thanking our panelists for their time and for the insight and the humour and the wisdom that they have shared with us today. The COMBAR guidance will follow. On behalf of all of them, good night and good luck.